Hello everyone, welcome to Authentic Forensic Medicine. In today's lecture, we are going to discuss some very important new topics. The topics are Bhartiya Nyaya Sanhita, BNS, Bhartiya Nakrik Suraksha Sanhita, the BNSS, and types of offences. These are very important short topics and very important for Viva questions. Sometimes the MCQs comes and sometimes also the short note questions also come from these topics. Now, students, we are here in medical profession to become doctors. We are not going to become lawyers. So, why do we need to study some basic laws like Bhartiya Nakrik Suraksha Sanhita, Bhartiya Nyaya Sanhita, and type of offences? The reason we need to understand is that students, we are dealing with humans. So, and humans get many times injured, and they accuse others. Sometimes there are assaults, somebody is hitting somebody. Some there's attempt to murder, and there are also cases very unfortunately there are cases like rape, child molestation, and all these cases there. And they come to doctors. They all come to doctors for treatment. So when we are in India, we need to know the Indian laws applicable to these cases. Because when we are treating these patients, it's also our duty to inform the police and to deal with police in such cases as a doctor. So we are going to learn about some basics of these in today's lecture. Let's start today's lecture. So friends, the first topic is Bhartiya Nyaya Sanhita 2023 and Bhartiya Nakrik Suraksha Sanhita BNSS 2003. Now what are these and what is the difference between them? Friends, in Indian system, in Indian judicial system, we have two main laws. These are very old laws, the IPC, the Indian Penal Code, and CRPC, the Code of Criminal Procedure. You can see here IPC is written. It was a law which was in practice in India from 1860 at the time of Britishers. We had our CRPC, but it was also very old, outdated, of 1973. So the government of India in 2023, it brought a new laws. It replaced IPC with Bhartiya Nyaya Sanhita and it replaced CRPC with Bhartiya Nakrik Suraksha Sanhita. Now, but what are these laws and what is the difference between them? So, this Bhartiya Nyaya Sanhita is substantive criminal law, and the Bhartiya Nakrik Suraksha Sanhita it's procedural criminal law. Now, what do we mean by substantive and procedural? So difference is that Bhartiya Nyaya Sanhita, this is the law where every crime is defined. What is a crime? The basic question answered here is what is a crime? What action of a human should be called a crime? So basically it defines all offenses like what is a murder? When do we say that person has committed a murder? What is a rape? What is the definition of rape? When can we say that person has committed a rape? What is an assault? When can we say the person has assaulted somebody? So all these offenses are described and defined in Bhartiya Nyaya Sanhita. Whenever the police has to decide that has the person committed a crime, they refer to Bhartiya Nyaya Sanhita, and with the particular section of the Bhartiya Nyaya Sanhita, they arrest the person. Even punishments are described in Bhartiya Nyaya Sanhita. For example, the rape has been defined, and next section, the punishment for the rape has been defined. That if a person commits rape, how much punishment should he be given? So all that is given in Bhartiya Nyaya Sanhita. So what is given in Bhartiya Nakrik Suraksha Sanhita? What is the difference? Now this law, Bhartiya Nyaya Sanhita, BNS, deals with the crime, guilt and punishment. But now when a crime has happened, what is the duty of the police? What is the procedure that police has to follow? For example, police comes to know that a dead body has been found. And the person may have died by a murder. Somebody may have killed the person. Now, what are the duties of the police? What procedure should police follow? That all is given in Bhartiya Nakrik Suraksha Sanhita. It explains the procedure of justice. What should the police do? What are the powers of the police? If the person has been arrested, then what should the courts do? What are the powers of the courts? How to deal with that case? How to deal with the accused? That all is given in Bhartiya Nakrik Suraksha Sanhita. Bhartiya Nyaya Sanhita defines offences. It prescribes punishment for offences, but it does not describe the procedure of law. No, it does not. Bhartiya Nakrik Suraksha Sanhita, It does not define offences, it does not describe the punishment, but it explains the procedure to be followed by the police and courts. So it is applicable to the accused, conduct whether the accused has committed a crime or not. And this Bhartiya Nakrik Suraksha Sanhita is applicable to the powers and procedures to be followed by the police, magistrates and courts. So this is the basic difference. And students, in our medical practice, we need to learn somewhere I can say about 25 to 30 sections of the BNS, and I can say about 5 to 10 sections of the BNSS. These are the maximum you have to keep remember and apply in your medical practice. Now coming to the next slide, next topic. Now what are the types of law? Now students, broadly, when we are dealing with these cases of disputes and crimes, there are four types of laws. One is the criminal law, other is the civil law, the third one is the common law, and fourth one is statutory law. Now what are these four laws? So criminal law, it's very clear from the name itself. It's here the law which deals with the crime. For example, crime has happened, a murder has happened, rape has happened, robbery has happened, assault, kidnapping. These are all very serious crimes, friends. So what should be done and what is done as per the law is all dealt as per the criminal law. Now students, whenever a crime has happened, please understand this is a very, very basic thing. It deals with offences against the state and society. Now why it's offence against state? What are we talking about offence against state? So it's whenever a crime has happened, like a murder happens, is it acceptable in a civil society? No, it's not acceptable. In a civilized society, where people want to live peacefully with justice, nobody wants crimes. And whose responsibility is it to stop the crimes? Responsibility first and foremost is of the government. And how does the government stop crimes? It takes the help of the police. So whenever a crime has happened, the police arrest the accused person, put him in the jail. Then the public lawyer, the government lawyer, known as public prosecutor, fights that case. Police collects the evidences, give it to the court, and the government lawyer, the public lawyer, public prosecutor fights that case. Whenever crime happens, it's the duty of the state I mean the government, to stop the crime and to get the guilty punished. So whenever a crime happens, students, it's the government which is fighting the case. That's why it's called offense against the state, against society. The relatives of the person who has been murdered do not fight that case. It's the government which is fighting the case. Accused is trying to defend himself with his own private lawyer. Accused has the right to defend himself, and he hires a lawyer, pays him the money, and that lawyer fights the case for the accused. But for the person who has died, it's the government which is fighting the case without any money, without asking a money from the family. So this is what we are dealing with criminal law. Now what is civil law? In civil law we are dealing with non-crimes. There is no crime in a civil law. Civil law is basically when there is a dispute between two different individuals or parties. For example, one person, another person, the two are having property dispute about land or about house. One person is blaming other person for a defamation, that he has spoiled my name, he's spreading lies about me, slanders about me. He has spoiled my name in the society. He can go to court and file a case against that person. A couple fighting a divorce case. Husband and wife, they are not getting together. They want to separate and they're fighting a case in court for divorce and for the settlement money. Now these all are not crimes. They all come under the purview of civil law. And coming to the next, what is a common law? Now friends, students, in a society, we have laws to deal with different kind of situations, different kind of problems. But sometimes there is a problem for which we do not have any law. Just an example of criminal negligence. In India, if a doctor is accused of negligence, that doctor has been negligent in his treatment, and because of some negligence of the doctor, patient has died. Now the relatives of the patient, they are accusing the doctor that because of his negligence, the patient has died. So they want the doctor to be punished. Now this will come under criminal negligence. But in India, there is no law to deal with these cases. That should the doctor be arrested, or first an inquiry should be conducted by another doctors, whether the doctor was negligent or not. So there is no law on that. So when such a case happened, this is a very important judgment of Jacob Matthews versus State of Punjab. Now there was a doctor, Dr. Jacob Matthew, and his team. They were accused of negligence. A patient died in a hospital, and Dr. Jacob Matthew and his team, the staff nurses or the doctors, they were accused of criminal negligence. That because of the negligence, the patient has died. The doctor was fighting his case to defend himself. This case went to Supreme Court of India. It went from Sessions Court, it went to High Court, from High Court it went to Supreme Court of India. When this matter went to Supreme Court of India, this was first kind of case which has come to Supreme Court. There was no law existing on how to handle these cases. So Supreme Court made a judgment on that. Supreme Court laid down the guidelines that whenever such a case of criminal negligence against a doctor is there, these are the guidelines to be followed by the police. In these guidelines, the Supreme Court made a guideline that doctor cannot be arrested directly. The police cannot arrest doctor unless and until there is already an inquiry by other team of doctors. And if that team of doctor finds that doctor has been negligent, then police can proceed with filing an FIR. Otherwise, FIR cannot be filed against a doctor. So these are the guidelines laid by the Supreme Court of India. Now this judgment has become a case law to be followed by for others. Because there is no law, so this judgment of the Supreme Court now will act as a case law, common law. So what is case law? Judgment made law based on judicial precedents. Because there was no other such case, now this is a guideline by Supreme Court. Now, in future all cases, this guideline will be followed. So now coming to statutory law. So these are the laws passed by the Parliament of India. What is statute? Statute means something which has been passed by a statutory body like Parliament of India. For example, statutory rape. The Government of India, the Parliament of India passed the law that in case of sexual act, if a female is below 18 years, even if she gives consent, she says, the couple says it was consensual act, it will be considered rape. So female will below 18 years of age, if found to be involving into a physical intercourse, the other man, a male will be accused of rape. It is a rape to have intercourse with a female who is below 18 years of age. This is a law passed by Government of India. This law was not there in BNS. There was no such law in India earlier. So the Parliament of India passed the law. Now because it has been passed by the Parliament of India, which is a statutory body, it's called statutory law. And the offence is not statutory rape. So students, these are the 4 types of law which we need to know and can be asked in exams as viva questions, and MCQs can come and short notes also can come. Now proceeding to next slide. Now what is an offence? Very commonly asked viva question. Define an offence. So offence means any act that you are doing something. Act means you are doing something, or omission. Omission, what is the meaning of omission? Omission means that you did not do what you were supposed to do. You omitted it. Omitted means aapne wo kiya nahi. You did not do that. So what is offense? You do something which you are not supposed to do, or you do not do which you are supposed to do. And this is punishable by law for the time being in force. As per the law existing at that particular time, something which you should have done or something which you should not have done, and if it is punishable by law, it is called an offense. For example, a person commits a murder, it's an offense. For example, a doctor. And now in the example of omission, I am giving example of doctor. Patient is there. Patient needs first aid. He is an emergent patient. He is about to lose his life. It's a critical case. Doctor should give the first aid to the patient, but doctor did not give first aid. So doctor omitted. It's an act of omission. And because of the doctor who is not doing his duty, if the patient dies, it becomes a punishable offence. It is defined under section 2(1) of the Bhartiya Nakrik Suraksha Sanhita 2023. So definition of offence means an act or omission made punishable by law for the time being in force. Now we'll come to types of offences, friends. Very, very important now. Very important viva question, and sometimes short notes also come. Now what are bailable and non-bailable offences as per the Bhartiya Nakrik Suraksha Sanhita? Now students, some offences is an offence, but for some offences, police can grant a bail. Now these are called bailable offences. These are very less serious offences. The matter need not go to court for bail. Even the police officer in whose thana or in whose police station the person is being arrested, the police officer has the powers to grant a bail. Here, bail is a matter of right. Person has a right to bail. Accused must be released on bail. And sometimes the police officer can get a written statement from the person. Sometimes he can ask for some kind of small amount of money to be deposited as a security for releasing on bail. And these are very minor small offences. Police can grant bail. So, for example, simple hurt. Somebody slapping somebody just having a small pushing somebody, punching small injuries, very small injuries. Defamation. Somebody drinking alcohol and creating public nuisance. Somebody is drinking alcohol and shouting in the public. Or somebody playing a very loud speaker, very high music in the public and disturbing others. Now, these are very small offences for which the police has the power to grant bail. These are called bailable offences. Now, what are non-bailable offences? Friends, these are the offences where the police officer does not have the power. Person can get bail, but to get the bail, person has to go to the court. Now, here the person has no right of bail. It's not a matter of right here. The judgment now depends on the judge, court. Court will decide that person should be given bail or not. Person can try for the bail. He can try to prove his case, but the end decision is with the court. Offense in which bail is not a matter of right. Bail is granted at the discretion of the court. These are very, very serious offences, friends. Very heinous crimes. Example, a case of murder, a case of rape, dowry death. A female being killed by the family can ask very difficult to get the bail for the accused husband. In these cases, punishment is very severe. Police cannot grant bail. Court considers gravity and evidence to grant bail. So, in serious offences, the bail is not a right. Court will decide whether the person should be given a bail or not. But in minor offences, small offences, police has the right to give the bail, and person usually gets the bail. So these are the bailable and non-bailable offences. Next, coming to the last topic for today, a very important question commonly comes in exam as short note and is many times asked in Viva questions. Now, what are cognizable and non-cognizable offences, friends? Cognizable offences are those offences for which police can arrest a person without warrant. See, there are two types of offences here. Offences where the police can arrest without a warrant, or the police cannot arrest without a warrant. So, if a police can arrest a person without a warrant, that means he is being accused of very serious crime. Police does not need a warrant now. Police can start investigation without court order. These are very, very serious offences for the safety of the public, so that no evidence is hampered, nobody else is hurt. For example, case of murder, case of rape, grievous hurt. Grievous means serious damage. Somebody is hitting somebody, is assaulting somebody, and has caused some serious damage to the person. Grievous hurt. In these cases, police can arrest a person without the warrant from the courts. FIR can be directly arrested by the police. And what are non-cognizable offences? Police cannot arrest without warrant. Police needs a warrant from the court's permission to arrest. That means these are very serious, less serious offences. They are not very serious offences. The punishment for them is very mild. Police cannot register an FIR, it can only register FIR after the court order. Simple assault, defamation, these are all bailable offences basically. So friends, so we have learned today the BNS, the Bhartiya Nyaya Sanhita, Bhartiya Nakrik Suraksha Sanhita. Then we have learned the types of criminal law, civil law, the common law, the statutory law. Then what is an offence and what are difference in bailable and non-bailable offence, and difference cognizable and non-cognizable. Very important short notes, important topics of Viva questions. So we'll meet next time with another important topic. Thank you.